April 2025, in Tamil Nadu versus Governor case, two judge bench of Supreme Court set a timeline for discharging the bills by the governor and the president. In case of using Article 2001, that means 200, governor has only 1 month to decide the bill. Second, in case of using Article 201, that is for presidential consideration, there will be 3 month timeline, and these timelines are basically set by the Supreme Court in April judgment. If governor fails to give the consent or assent within 3 months, the bill be considered as a deemed assent. That means without even the consent of the governor, the bill become the law of the land, which has been passed by the legislature. Now this annoyed the union government. Union government responded the judgment, and President of India sought clarification of this ruling with presidential reference. This presidential reference power under Article 143, President asked 14 questions to the Supreme Court and seek clarification about this ruling. Now in recent 5-judge bench, constitutional 5-judge bench, Supreme Court clarified some of questions out of 14 questions imposed by the government, that is a president. Court has clarified here. Under Article 200, governor has only 3 options. When I say only 3 options, that means only 3 options to decide the bill. The first option, governor can grant the assent to the bill. That means subscribe the bill. Second, reserve it for the consideration of the president, under article which comes under Article 201. And third option, governor has withhold the assent and return the bill to the state legislature with comments if that particular bill is not the money bill. If it is a money bill, so he cannot send it back to the legislature. In second question asked by president, what about the discretionary power enjoyed by the governor under Article 200? That is a complete discretionary or not? Supreme Court also clarified here. Governor enjoys absolute discretionary power, and governor is not bound by any advice given by Council of Minister, which is headed by the Chief Minister. And in third answer, court clarified that this power of discretion of governor is not justiciable. That means you cannot challenge this discretionary power before any court of law on prima facie. However, in case of prolonged, unexplained delay, Supreme Court can issue a limited mandamus to the governor. That means here Supreme Court has very limited advisory role while deciding the matter, while deciding or granting the assent to the bill. In fourth question, bench also clarified that in case of the using Article 201, that is the presidential consideration, this matter is also not justiciable, so before any court of law. And in fifth question, bench basically clarified, I cannot impose any timeline on the decision decided by the governor or the president while assenting granting the bill, because it violates the basic structure of doctrine, which is a basic structure. And what is this basic structure? Separation of power. While in April month, Supreme Court has set 3-month guideline, a 3-month timeline imposed by the court. If delay happened, the bill will be considered deemed assent. But now court reverted this argument. There is no such thing like deemed assent is mentioned in original constitution. So how can a judge, how can a court can impose such things like deemed assent? A bill cannot become a law without the proper assent of the governor. And in sixth answer, court said this provision of not imposing timeline also applies to the president. That means both president and governor can decide the matter whatever the time they want. In seventh question, court replied, President or governor enjoys absolute personal immunity under Article 361. So they cannot be brought before any court of law except as a case of public office, because he is holding as a public office. So in cases of he can be brought, otherwise not. In eighth question, court said the constitutional power of president or governor cannot be substituted by the decision under Article 142. That means the earlier judgment which said that clause, the particular clause deemed assent, is now unconstitutional because such a thing nowhere is mentioned in original text of the constitution. So what is deemed assent in case of the deciding governor, in deciding the bill by the governor, is not valid. In its ninth answer, bench argued judicial review is not available on the content of the bill. That means until the bill becomes the law of the land or act, you cannot seek judicial review on a bill itself. Governor cannot be, that means the decision of the governor cannot be judicially reviewed. The merits on which basis the governor will decide. In 10th answer, court said, seeking advice by the president under Article 143 on any bill depend on the president's choice. It is her choice whether she wants or not. But they are not bound to seek the advice on every single bill which has been referred to the president. They are not bound. These are answers replied by the court on all those 14 questions. Some are obviously left. President asked these 14 questions under presidential reference, that is the power given in constitution under Article 143, and this 5-judge Supreme Court constitutional bench replied and clarified, and few of them left. So but these are just opinion and not binding on the government. Let us see how many advice will become the law of the land in future.